Do we follow Aristotelian logic? If there are two people, four breads, Aristotle would say give two breads to each one of them. Based on logic. Equality, good or bad? But one person would be like me, eats too much. I need 4 breads or 3 breads minimum. And the other person may be on dieting. Even 1 bread is more than enough for him. If you give him 2, 1 is wasted. And if you give me 2, I am still hungry. So law would say, logic would not say that you give me 3 and give 1 to the other person. This is not formal equality, this is substantive equality. It may not be based on complete logic or Aristotelian logic. So if law is also organized principle from a political point of view and is based on reason and principles and is in fact a study of logic is efficient application of legal principle, then law is basically applied logic. Generally. Except that there are situations where what you consider logical, like in this example of equality, the substantive equality, on the face of it, it will not look logical, but in reality, it would be logical. Except those exceptions, basically logic would be based on common sense, on principles of fairness, on principles of what you would call justness or reasonableness. So legal reasoning at times may be different from ordinary reasoning. I am not denying that. So 2 and 2 may make 4, may also make 5 or 6 in law. If someone has committed theft of a mobile and convicted 100 times, and again today one mobile is stolen, and somebody saw that person with that mobile, and that person is prosecuted, you will not be allowed to give evidence in the court telling, Your Honor, this man has been convicted 100 times for the theft of mobile. Looks logical, but law will not permit it. Because the principle is that in this case you bring evidence that he has committed theft. Evidence of past bad character cannot be given. May look illogical but has a purpose for a principle. And I told you that logic is also a principle. So you will not be allowed to give evidence under new Bharatiya Sakshya Adhiniyam. Why they say it is a new law when 99.9% they have retained the 1872 Indian Evidence Act. There is nothing new in it, including electronic evidence, which was already brought in through amendments. And this rule has been retained, that evidence of past bad character cannot be given. Except in reply. This is also logical. Generally, you cannot say that this man committed theft 100 times, therefore he must have committed this time as well. But if this man say, I am such a good person, never committed a crime, then you can say, no, he has been convicted 100 times. Looks logical now. So legal reasoning should also be ordinarily based on some principle, should be based on reason. Law should be dictate of reason, should be based on principles of fairness. But there are any number of cases, and Aman is right when he says that recently in our WhatsApp chat, so many judgments have come which are absurd. Just last week, Supreme Court bench of Justice J.K. Maheshwari and Sandeep Mehta gave a judgment that if there is a case of a negligence against a doctor and doctor has died, then his son or wife can be pleaded as a party. Have you read about negligence? Anything about consumer law?
Yes.
So consumer law was passed in 1986. Now consumer law defined services. If services are given for free, like if you go to a government hospital, then it is not a service. Say if the food which 82% of Indian population is getting is bad food, not good for human consumption, you are a beneficiary. And therefore a new constituency in the electorate has been created called Labharti, or beneficiaries, and they will vote for the BJP, irrespective of religion, race, caste or place. Big chunk of people. But anything which you get for free is not covered. I'm not sure whether courts will look at it that some of them don't get it for free. If they have to pay 1 rupee per kg of wheat, it is not for free. And then if it is deficient, it should be covered by services provided. But services provided by the government will not be considered services. And there will be no liability under consumer law. But medical services, the law was passed because some doctors were grossly negligent. Somebody's right eye is to be operated, they operated the left eye. Somebody left a towel in the stomach during operation or a seizure in the stomach. For such cases of gross negligence, this law was passed. Now, in this case, a patient came in severe pain, she was operated. After 35 days, she complains again of a pain, she was again treated. Then she came to Shankar Nethralaya in Chennai. The other eye was operated for glaucoma. And then the husband moves against the doctor. Now, the doctor was highly competent. I have not seen any ophthalmologist who was also MS ENT, but this doctor was MS ophthalmology, Dr. Lal, as well as MS ENT, and then also had a degree from London, widely known in Munger. So the District Consumer Forum gave some 4.5 lakh compensation. The doctor moves in appeal to the state forum. As you know, under the consumer law, you have a district forum and a state forum and a national consumer forum. They said, well, there is no report of expert that the doctor was negligent. No evidence has been given.